So you all have the list. You all have the list. Let me go over the list for a few minutes, and I'll bring your attention to a few things. And then after that, I'll be happy to take as many questions as you guys can come up with. Okay? As I announced in class, the first question will just be the kind that you would have gotten in undergrad, talking about obligations in general and conventional obligations. All I'm going to want in that section is the general rules, general definitions. And I don't know where you guys got the idea that there are elements of an obligation. There are no elements to an obligation, okay? There are elements of a contract, but there are no elements of an obligation. There are effects of an obligation. There are times when obligations are created or extinguished, but there are no elements of an obligation. Obligations have different sources. We talked about that, from tort through contract, by way of quasi-tort and quasi-contract. Okay. I'll also need you to understand the difference between an offer, an irrevocable offer, and an option, which is a contract. Be able to recognize when you have one, when you have the other, and when it might be unclear. Okay, I've tested this on prior exams. I'm testing it now. An irrevocable offer is one that gives you either a specified time or just indicates that you have some extended period of time as the offeree during which you'll have the power to accept it. Okay? We had a case where after 36 days, the offeror of an irrevocable offer revoked it. How did he revoke it? By the same means that he had offered it in the first place. And the court held in that case that 36 days was a reasonable time. Now, if an offer stipulates a time, it's an irrevocable offer for a stipulated period of time, but that doesn't make it a contract. It's still an irrevocable offer. So if the offeror changes his mind and said, yeah, I know I gave you 4 days, but I'm cutting that back. I've changed my mind. I don't want to sell it anyways. Okay, what can he get for that, for revoking an irrevocable offer before its time is up? What damages can he be forced to pay? Pardon? Reliance? Did I hear reliance damages? You would probably be correct, okay? And that's going to be hard to prove in that instance, because what nitwit would go out and spend a whole lot of money that he hasn't really got a firm commitment on buying yet, right? That he doesn't have a contract. I just have an offer to buy an H1, so I'm going to run out and build a $20,000 garage for my H1. What? Okay, what? You know, it doesn't make any sense. Now, how would you know if it's an irrevocable offer or an option? An option is a contract, and the effect means that if you breach an option, you can the other party can demand specific performance if it's available, or expectation damages. That's a pretty big difference in effect. Okay, that's a pretty big difference in effect, but the issue is being able to recognize one so that you can then determine what effect would result. So if I told you, I will offer to sell you my copy of the Civil Code worth $50 for $25, and I'll let you think about it for a few days. Option or irrevocable offer? Irrevocable offer. I'll let you think about it for 3 days. Option or irrevocable offer? I don't know for sure. Probably irrevocable offer. Why? Because there's no objective intent to be bound to that term. Okay? What if I said the same thing? I will let you buy, I'll buy my copy of the Civil Code for $25. I'll give you 3 days to think about it. And I'm so eager to sell this that I'll even write it down and sign my name and date it. Which now? Probably an option, because I have indicated an intent to be bound to that promise legally. What if I said, okay, if you give me $5 as a down payment, I will keep the offer open for 3 days? Probably an option. Again, there's some objective intent to be legally bound. Now, Litvinov disagrees with this, so it's pretty much up in the air. There hasn't been a case on it that I've found, but I think that the most important principle that I can teach you here is learning to look for an objective intent to be bound. It's a fundamental concept in contracts and in obligations. The objective intent to be bound. Yes, Ms. Burrell, I see your hand is waving.
In contracts, when we did contracts, we had to have money to have an option contract. But in Louisiana, we don't have that.
In contracts, you had to have consideration to support an option. However, if you read the restatement second of contracts, it will tell you that in some jurisdictions, nominal or recited consideration, or even no consideration, is enough. So whatever jurisdiction you end up practicing in, you will need to look to see what is required for an option, okay, to make it enforceable. In Louisiana, the Civil Code stipulates no consideration is necessary. Although we had some old cases that did require consideration, that had changed quite a while ago. Okay, detrimental reliance. Remember, you have to have a promise of a certain nature such that the promisor should foresee that it is likely the promisee will rely on that promise to his detriment. In other words, it has to be a specific kind of promise. It has to have enough details so it'd be reasonable to rely on. The promisee's reliance has to be caused by that promise and has to be reasonable. And third, and probably most important, there is no other remedy. There is no contract that would afford a better measure of damages or a higher measure of damages. There's no contract in place. Okay? And then damages will be awarded as justice requires. Hi guys, I know I look tired. Okay. Capacity. Capacity is what? Presumed. Capacity is presumed except in cases of minors, interdicts, and those deprived of reason when? At the time of contracting. Make sure you understand what deprived of reasoning at the time of contracting means. It doesn't mean drunk to your gills necessarily. It means that for whatever reason you are unable to understand the nature and consequences of your actions. You're unable for some reason to understand the nature and consequences of your actions at that time, and what else the other party knew or should have known of that. Okay. For some reason, law students always glom on to, oh, well, he must be drunk, so I can get out of the contract if I'm drunk. Courts don't look at that very kindly. Okay. Were you forced to drink? Unless you are the character Roger Thornhill in North by Northwest, where they sat him on the couch, tied him down and forced him to drink a bottle of scotch, or I think it was bourbon. Okay. It's unlikely. It's unlikely. There are some courts that might that will reverse for that, but it's again unlikely. There's got to be some indication of taking advantage on the part of the other party. Okay, capacity. We talked about dead folks' capacity. Donations. Now, we had a hypothet on donations, but I'm concerned because I'm not sure that all of you finally understood that a donation is not effective until it is accepted. Okay, it's not effective until it is accepted. And what does the form of that acceptance have to be?
It has to be authentic. No, it just has to be right. If it's an immovable,
Okay, I hear something about, first I heard a whole chorus of it has to be in writing, then I heard something about movables, immovables. Okay, so the first thing you want to distinguish is whether the thing in question that's being donated is an immovable, corporeal or incorporeal, or whether it's a movable, corporeal or incorporeal. If it's anything other than a corporeal movable, then the donation itself has to be an authentic act form and signed by the donor in order to be at all effective. The donor has to be the one whose signature is an authentic act form. The donee then has to accept in writing. If it's a manual gift, what do you have to have? Donative intent and delivery. What is donative intent? We're back to the objective theory of contracts. The intent to give it to you, okay? The intent to give it to you, okay? Now, can you give a corporeal movable by means of an authentic act? Of course. You just don't have to. Okay, you certainly may, but you don't have to. Good morning, Mr. Cuvillon. Okay, good morning, Ms. Williams. Okay, we've finished donations. Let's go on to natural obligations. Remember, what is a natural obligation? The law implies a moral duty. The law implies a moral duty, okay? It is enforceable or not enforceable? Not enforceable. It's not enforceable, okay? But what you give in connection with your moral duty or your conscience is you can't take it back. What are some examples of a natural obligation? Some examples that the code gives. Pardon? No, that the code gives. Repay a debt that has been, no, sorry, okay. That used to be the law, but what the civil code says is repay a debt that has expired because it has prescribed, okay? It would be unlawful under federal law to repay a debt that has been discharged in bankruptcy. Okay, be unlawful under federal law. Am I going to test you on that? No, because this is not a course in federal bankruptcy law. This is a course in obligations. So you'll be required to know that debts that are discharged due to prescription can be the subject of a natural obligation. So can obligations given by a will or testament that is unenforceable. Okay? Check the code out. Now, remember, it's where the law implies a moral duty. So there are other examples that we learned from case law, and one of them, as was mentioned by the class, was that a stepdad who felt guilty about his stepson's ending up in rehab, okay? Or an adulterous husband who agrees to give the house to his wife, okay? He certainly didn't seem to feel guilty, but the court felt he should feel guilty, right? So it's where the law implies a moral duty. Okay, then to whatever is given in connection with a natural obligation cannot be reclaimed, but a natural obligation can essentially be the cause of a conventional obligation. Okay, so if there are 5 markers that you use to see if a natural obligation was elevated to a conventional obligation, and those 5 markers are duty to a particular person, some indication of strong conscience or a strong conviction that on the part of the obligor that this is a wrong that should be remedied. The obligation can be fulfilled pecuniarily, that means with money, right? Some clear and unequivocal statement on the part of the potential obligor that he intends to fulfill this obligation. And finally, the obligation is not against public policy. Okay? Remember the clear and unequivocal part. Remember, that case was from the guy who, when his car dealer called him up and said, "Hey, dude, I just learned that you filed for bankruptcy. What gives? You've never missed a payment." He said, "Well, I intend to pay it all off. Don't worry about it. The next payment is in the mail." And he made 3 payments after that. And the court says, what? Is that clear and unequivocal? No. No, the court said that was not clear and unequivocal. I intend to keep paying. It's not in writing. It's not a firm commitment. As a matter of fact, it would have been against the law for him to continue to do so under bankruptcy rules. Okay, vices of consent, error, fraud, and duress. Error, fraud, and duress. Remember, fraud is what? You define fraud? Misrepresentation or suppression of the truth made with the intent to gain an unjust advantage or cause an inconvenience or disadvantage to the other party. Okay? Doesn't necessarily have to cost money. What case did we have that showed a fraud where it didn't cost the guy any material damage? Remember, that was the farmer, the homeowner who would never, ever, ever have sold to his next door neighbor? Okay, and the guy tricked him. Okay. Okay, it was two neighbors who lived next door to each other. There was a strip of land that the evil neighbor wanted. And the good neighbor would never, ever have sold it to him because he hated the guy. So the evil neighbor hires his friend, puts title in his name. What is that called when you put title in somebody's name, but you really intend the two of you to have no... Right, it's called a simulation. And to have no effect whatsoever, what kind of simulation would that be? Absolute simulation. So it was an absolute simulation, okay? The good neighbor ends up selling this strip of land, and when he discovers he sold it to evil neighbor, he is very upset. There's a seat right down here in the very front. Other than that, I think we're going to be borrowing chairs from next door. Okay. Oh, there's 2. Okay. So the good neighbor ends up getting his property back because it was obtained by fraudulent means. Okay. Damages. How do you calculate damages? Loss sustained and profit of which you've been deprived. Okay? Loss sustained and profit of which you've been deprived. Be able to calculate that. I expect you to be able to handle 3rd grade math. Okay? Solidarity. Solidarity. Listen up, because this is something that I'm not sure I made as clear as I should have. Solidarity is never presumed, right? It's the same as joint and indivisible. It's never presumed. Now, a contract or a debt instrument that's creating a solidarity debt can do so by using the words insolito, solidary, or anything that is the equivalent. So if it were something like, we bind ourselves together with and for each other for the payment, if it were something like that, that was that specific, that could show the intent to be solidarily bound. It's never presumed, but if you have reasonable language indicative of the intent to create a solidary obligation, that is enough, okay? Reasonable intent. In courts in general, There are no magic words. We can call something a sale, but if the court looks at the party's behavior and it looks like, well, it was for a very low price, the buyer never actually got possession of it, this is actually a loan, okay? So they called it a sale, but what they wanted to do was create a loan. So we're going to call it a loan, okay? The court is going to look at what the parties do, not what they say about what they're doing. So the court is going to look at the intent behind the language, not necessarily look for any magic word. Okay? Remission. Remission. Remission is what? Forgiveness of a debt. It is presumed if the obligee turns over the instrument of debt to the obligor, okay? It is absolutely created if he writes paid in full or something else on it. Okay? Remission and solidarity, how does that affect? If a creditor or an obligee remits or in favor of one obligor, one solidary obligor, or if he lets that solidary obligor go by means of a compromise, then what happens to the debt? It is reduced by that virile portion. It is reduced by that virile portion, not by the amount that he received from that obligor that he's letting go, but he's reduced by that virile portion. Okay. Okay. Remission means the forgiveness of a debt. Okay. So if one of a number of solidary obligors is let out of the debt by means of remission, that means he is forgiven. He doesn't have to pay a thing. Or if he is out of the debt because he reached a compromise. Ms. Cruz, there's a spot right up here in front. If he reached the same thing by means of a compromise, he's let out of the debt because he compromised with the obligee, then the entire debt is reduced by his virile portion. The remaining solidary obligors owe the original amount minus that virile portion. So if there are 3 obligors and one is remitted and it's an obligation, a debt for $300,000, how much will remain of the debt? $200,000.
Oh, so that amount just goes away?
It just goes away. Right, just goes away. And he's gone. He can't come back in. He's done. Yes, Ms. Dunaway.
If he only pays 50, it's still reduced by 100,000.
Yes, ma'am. That's called a compromise, right? Okay. If he only pays 50, it's still reduced by 100,000. Yes.
The whole issue with one of the obligors being at fault for something,
Mm-hmm.
when the other solidary obligors are getting a contribution, is that reduced by their own virile portion?
Okay.
If someone's at fault,
If one party is at fault, one solidary obligor caused the whole thing. The other guys are still solidarily liable, so they may have to kick into the obligee, right? So once the obligee is all paid off, then among themselves, instead of contribution where you divide it by virile portion, there would be indemnification. The one who's at fault is going to have to pay back the other 2 for whatever it was they paid.
So it's not reduced by their virile portion for the ones that actually had to pay for the person at fault.
Among themselves, correct. Okay? And I expect you to be able to find that article in the Civil Code. Why do I expect you to be able to do that, Ms. Dunaway? It's only once you do that that you'll really understand it and know it and see
I
it.
looked at it yesterday, but it wasn't very clear.
Okay. Well, now look at the language again, now that I've given you an explanation, and link the two, and that way it'll be firmly ensconced in your hard drive up here. Okay? Yes, ma'am.
If you have 3 people who are solidarily owe an obligation and one person is
If you have 3 people who owe a solidary obligation and one person is granted remission,
And then of the remaining 2, one's
And then of the remaining two, one becomes insolvent. I'm repeating for the benefit of the movie.
Is the last named person liable for both of those 0?
No, ma'am. No, ma'am. He's only liable for the himself and the one who became insolvent. That's what you meant. Okay, okay. So if we had that same $300,000 debt, and one went away because of remission, that leaves a $200,000 solidary debt and two obligors. If one of those obligors goes insolvent, then the other one has to pay the obligee $200,000. Okay? And he can go after the insolvent one and put a claim on any future income in order to get his now $100,000 back. Okay? So that's different from renunciation of solidarity. Okay? Where that third guy would have to come back in. Okay? Okay. Performance by a third person. Promesse de portefort. Remember I said this is a strong arm theory? It's an article that appears in the section just before third-party beneficiary. Okay. And what it says is that the object of a contract may be that one party gets a third party to obligate himself. The object of a contract may be that one party gets a third party to obligate himself. So instead of getting a benefit, the third party here gets an obligation. Okay. Now, you can't force a third party to take on an obligation. So if the third party refuses, then what can the obligee do? Can he sue the third party? No, he can sue the promissor. He can sue the promissor, okay? Assumption. Assumption. That's when you add a new debtor. You add a new debtor. It can be by agreement between the obligor and the new obligor. That's sort of the classic third-party beneficiary example that we've seen. Or it can be by agreement between the obligee and the new obligor. The difference is that the first one creates a solidary obligation. Okay? First one creates a solidary obligation. With the second one, we're not clear. We haven't gone into that much detail on it, and I would not worry about it if I were you. Okay. Yes, not at least at this stage. Yes, ma'am.
My question is, what would be the actual difference between a third-party beneficiary and an assumption?
A third-party beneficiary contract where the promissor agrees to assume the stipulator's pre-existing debt is an example of an assumption. Okay? It's a classic example of an assumption. Okay? Those two sections, third-party beneficiary and the section on assumption, are related. They overlap. They overlap in part. Okay? Let me illustrate it again. Let me check and make sure that this is in fact there's my dry erase. For those who are night students, I once had the day students in giggles because I wrote on this blackboard in permanent ink instead of dry erase. Okay, so we have a stipulator who has a contract with a promissor. Okay? And there's a third party. With a third party beneficiary contract, the promissor agrees to perform some sort of obligation, which they call a stipulation. They're generally, usually, is a pre-existing relationships. It can be family or debtor or other, like potential liability. When we looked at third-party beneficiary contracts, we looked at, I don't know if we saw some that were family. Instead of paying me, please pay my daughter the money that you would otherwise owe me. Is there anything wrong with that? No. I could pick a stranger. I want to make a donation to the American Cancer Society. So instead of paying me, give the money to the American Cancer Society. Okay? So some kind of relation. We had another kind of example where there was a potential liability. And that was soybeans. Onderpont. Remember in the soybeans case, there was a potential liability because the stipulator, the landlady, owed a duty to her tenant, the farmer, to protect his crops. And she delegated that duty to the promisor, okay, by means of a third-party beneficiary contract. So if there's any damage done to the soybean crop, who is going to pay for it? The stipulator. But the vast majority of cases that we looked at, there was a pre-existing debt. Pre-existing debt in the form of usually a mortgage. And what happens here is that the promisor assumes the stipulator's debt. Okay? So this is, in these cases that we had here, that was an assumption as well as a third-party beneficiary contract. It was a third-party beneficiary contract that included an assumption. Okay? So you can go back and look at those cases, the third-party beneficiary contracts that involved an assumption, and you can cross-index with the assumption rules. You can cross-index with the assumption rules. So what happens when you assume a debt? You become solidarily liable with the original debtor. You become solidarily liable with the original debtor because the mortgage holder, the bank, is much happier having what? Two debtors, not one. Okay? Now, if that banker, for what reason, for some reason or other, decides that debtor number 2 is a whole lot better risk than debtor number 1, he may decide that it's worth his while to remit the debt for the original debtor, in which case that's called, it's not remission of one solidary debtor, it would be a novation. He's substituting the new debtor for the old. It goes on the party's intent. It goes on the party's intent. It's a subjective novation. Got it? Miss A2, did you have a question? I saw your hand waving up and down. Can you have an assumption without it being a third-party beneficiary? Possibly. There are times when, if you look at the assumption rules, you have the new debtor going directly to the obligee. Instead of contracting with the obligor, he goes to the obligee and says, I want to pay off George's debt. Okay, so he may be obligated to pay off George's debt, but once he does, he may or may not be subrogated to the original obligee. Okay, he may be stepping into the shoes, so it may turn into a new creditor. So not a third-party beneficiary contract, but instead a subrogated contract. Okay? So it depends on whether it's new debtor to new debtor, and new debtor to old debtor, or new debtor to creditor. Okay? New debtor to creditor, as to what the end result is going to be. Okay, contractual interpretation. Contractual interpretation. Remember, I fussed at you guys on the reviews because I want you to understand that understand the sequence of rules in this section. In this section of the code, there is a sequence of rules that must be followed in order. People always want to say, oh, well, if it's something like if it's a contract of adhesion, we interpret it against the drafter. That's not the first rule. That's a last resort rule. Okay, that's a last resort rule. Okay. First rule is determining the parties' common intent, and if the rules are clear, explicit, and then there's no room for any further interpretation. Okay, there's no further interpretation is necessary or allowable. And you look at the general definitions of terms, or you look at the technical definitions of terms. It's only when the words are susceptible of different meanings, in other words, are ambiguous, that you start using some of these other techniques. Okay, and the next batch is, well, look at the words in context. Interpret them in light of other clauses in the contract to make them consistent, and interpret them in a manner that makes sense, not one that leads to absurd consequences. Okay? If the parties left out a term, that's different from ambiguity, isn't it? If they left out a term, then the court will imply whatever law, equity, or usage would imply as something the parties in contracting had actually agreed to in order for them to enforce the contract. Okay? It's only when you can't use any of those methods to make sense of the contract that you'll then interpret it either against the drafter, okay, or against the obligee. Okay. Nothing else makes sense, then you interpret it against the drafter or the obligee. Okay. Revocatory actions. Okay, one of the last subjects we studied. Word to the wise, make sure you understand prescription with regard to revocatory actions. And the prescription says that, let's see, compensation, confusion, revocatory action. I'm looking for the section. The easiest way, of course, would be, bless you, to look it up in the index. Again, I'm sorry it's warm in here, and I'm sure it must be warmer there because you guys are close together. They don't have air conditioning. Just be glad it's cooler than usual. 2096, thank you, Miss. 2936. 2036, okay. That's the definition of a revocatory action. Definition of a revocatory action: an obligee has the right to annul an act of the obligor or the result of a failure to act of the obligor made or effected after the right of the obligee arose that causes or increases the obligor's insolvency. Okay, that causes or increases the obligor's insolvency. Okay. So that definition is covering both revocatory and oblique actions, because revocatory doesn't cover failure to act. It covers an act made or effected after the right of the obligee arose that causes or increases. Now, the action of the obligee, 2041, must have, make sure you understand 2041, must be brought within 1 year from the time he learned or should have learned of it, or the result of the act, or the result of the failure to act of the obligor, that the obligee seeks to annul, but never after 3 years from the date of that act or result. The 3-year period shall not apply in cases of fraud. Okay, so make sure you understand that provision. Proof of obligations. Okay, especially confession. What is confession? When you admit to something under oath. Okay, when you admit to something under oath. Kinds of obligations: understand real, personal, heritable. Subrogation, make sure you understand partial subrogation. Partial, make sure you understand partial subrogation. Understand the consequences of indemnification clauses that indemnify a party from gross negligence, intentional tort, or personal injuries. No, that's different. You do need to understand non-pecuniary damages. That's included in damages. Okay? You also need to understand bad faith damages, included in damages. But you cannot have indemnification clauses that indemnify a party from his own gross negligence, intentional tort, or personal causation of personal injuries. And that is in articles, let's see, it should be under damages. (2004). Any clauses null that in advance excludes or limits the liability of one party for causing physical injury to the other party. Any clauses null that in advance excludes or limits the liability of one party for intentional or gross fault that causes damage to the other party. You can have limitation of liability clauses that limit what kind of liability? Probably solidary liability when somebody didn't cause the problem. And we talked about what the CVS example I gave you. It was originally Katz and Bestoff. I gave you a hypothet based on a case. A little old lady goes into, it was then a Katz and Bestoff, but you could substitute CVS or Walgreens. And she falls down the broken steps and gets injured. She sues everybody in sight. And the landlord says, well, we're not liable because we have this clause that says that CVS or Katz and Bestoff will insulate us from any potential liability for personal injury by a third, sustained by a third person. Well, those clauses are only effective insofar as they were not caused by the fault of the owner, of the one who's insulated by the indemnification clause. In this case, if CVS or Katz and Bestoff, it was Katz and Bestoff, knew that the stairs were bad. Okay, it was their responsibility to fix them. Therefore, when she slipped, it was their negligence, so they are held liable despite the indemnification clause. Now, we had another contract, remember, where we had a Burger King being built? Remember, we had a Burger King being built? And remember, in that case, there was also an indemnification clause, and that one was okay. Why? Because who was negligent? Was it Burger King? No, they had absolutely no control over the premises. That was the contractor. Okay, so that clause was okay because they weren't insulating themselves from their own fault. They were just insulating themselves from liability for somebody else's fault. Okay, that kind of indemnification clause is okay. Novation, that's when you're substituting either a new object for an old object or substituting a new party for an old party. Okay. Reciprocal obligations. Okay. What is the effect if one party doesn't perform on a reciprocal obligation? Then the other party doesn't have to perform. Okay. Management of the affairs of another. Negotiorum gestio. Remember the case we had was what? The car case where the guy's driving, test driving the car after having fixed it, gets hit. Okay. Suspensive and resolutory conditions. Okay. Now, suspensive and resolutory conditions. Remember what those were? Yes, it is. It's the last thing on the list.
No, the last thing on the list is reciprocal obligation.
Oh, okay. I added it. Because it's the extra credit question. Okay. Scared you. Okay. Yes, ma'am. I'm sorry, there's too much talking in front. Hush it down. Yes?
You had it ordered on the list as reciprocal obligations. That's a bilateral?
It's a bilateral contract or a commutative contract. You can use any of those terms. It all means the same thing. Okay? One party is both obligor and obligee. The other party is both obligor and obligee. Okay? Each one owes the other a performance. Each one is getting something from the other person. Just depends on how you're looking at it. Okay. Okay, so the extra credit question will deal with suspensive and resolutory conditions. Now, when it came to writing the exam, I took all 10 of the multiple choice questions are drawn from the questions you guys submitted. That being the case, there were a number of them I had to change. That means simplify. There are a number of them that I simplified. I shortened them. I took out some names. I reduced it to one issue, okay, because there were 2 or 3 sub-issues going on. So the multiple choice questions are most likely, some of them, easier than the form that they were originally submitted in. And in a few cases, the form they were originally submitted in was actually wrong, okay? So they're now correct, okay? But they are drawn from your ideas. So if you understand these topics that are listed, you should do just fine with the multiple choice questions. I would not go searching through for 4 hours all of those MCQs that are posted. It would be a waste of your time at this point. You have 2 days before the exam. The best use of your time is to basically go through and nail the concepts as in the code and as discussed in the cases. In other words, write and rewrite your outlines. Get comfortable with them. Make sure you can apply the concepts, that they're not just words, that you understand them. And finally, Sunday night, 8 hours of sleep. If you don't know it by Sunday night at 10 p.m., it's a wrap, okay? You're not going to know it by Monday morning at 8. You're not, okay? The only thing that you'll do is screw up everything you do know. Honestly, if you come in and your brain is so pickled from exhaustion that you can't write and you can't think, what do you think your grade's going to do?
Probably at least a D plus.
No. No, if I can't tell that you actually sat in that chair and understood what was going on, I can't give you better than an F. Okay? Do I like to give Fs? No. Bear in mind, I do have to follow a curve. The curve does not mandate that I give any Fs. I don't have to give any Fs, nor do I have to give any As. But if somebody earns an F, do you honestly want, the rest of you, do you want that person dragging you down the rest of the way through your career in law school? I want that person to repeat the course, okay, until they get it, okay? Hopefully that's not going to happen to anybody. Okay? Hopefully it's not going to happen to anybody. But the best way to avoid it is to make sure that you get some sleep.
So our exam is that night, right?
Yes, evening divisions exam is that night. The exams are not exactly the same, but they cover the same topics.
Can we take?
No, you can't switch. Okay. Day division students are not going to be allowed to take the night division exam 10 hours later. 6 hours later, however. And all pieces of materials that you are given during the exam, everything, scratch paper, the exam itself, your blue books, all of that has to be turned into me at the end of the exam. There will be a box for it. Okay. Make sure that you understand how to use ExamSoft. Make sure that your computer is in good condition. I think 98% of you are using computer. Okay. Any questions on the exam? Any questions on topics? Ms. Cruz?
It's more form.
More form?
Yeah, you said it was 10 multiple choice.
10 multiple choice preceded by 2 hypothets. Okay? Now the hypothets are broken down into sub-questions. The first hypothet, you'll look at it, and there'll be just a tiny little bit, and then each question after that gives you more facts. So each question is going to be its own IRAC, right? Its own issue. Okay? Make sure you read all of the subparts before you start answering anything. Okay? The second hypothet gives you more up front, followed by a series of questions. Okay? Again, make sure you read all the questions first and identify the issue that's being addressed before you start writing. And I will be looking for T-bars. If you don't have T-bars, where you have more complicated issues, I will subtract 5 points. Okay, so you have to judge whether this is a complicated issue or whether it's a straightforward issue. I should see some notes of some kind for each hypothet question. Yes, Ms. Stevenson.
This is kind of on the list. You have kinds of obligations on here, and I'm confused because you said that suspenseful conditions and stuff are added, but that's under conditional obligation. So do we not need to know the real obligations and all the strict stuff?
Okay. I included kinds of obligations by which I meant real, personal, and heritable. And then at the very end, I added suspensive and resolutory conditions. That will be the subject of the extra credit question. Okay? Extra credit question. Okay? The extra credit question at this point stipulates that you can earn up to 25 extra points on it. So if you bombed elsewhere, you have a good chance of redeeming yourself substantially. Okay? Yes, Miss A2. Shh.
I'm just asking, since you have
I think you'll just have to see on the exam when you get it. And use your good sense.
We can talk about kinds of obligations then, you can go in further detail.
Yes, I understood her question. And I drew a line in the sand. And said you will just have to read the call of the question when you get it and answer what the call of the question asks directly. Don't go, if it's a 50-point question, how much time should you spend on it? A half hour and no more. So how much detail are you going to want to go into? A half hour's worth of detail. If something is going to be asked later, I wouldn't go into a great deal of detail on it. That being said, I don't know. There are some people who have memorized the list before, and I never noticed that it gave any beneficial effect whatsoever. It's much better to really understand the content of the list than to waste your time memorizing the list. It would take you, 2 hours to memorize the list? That's 2 hours you could be spent studying the topic. Okay. Think smarter. I want you to study more smarter, less harder. Okay? More smarter, less harder. Okay? Now that you've made it through one semester, now it's time to get more efficient about things. Okay, other questions? Questions about topics? Questions about things you don't understand? Yes, Ms. Dunaway. Shh.
For partial subrogation, who gets paid first?
The original obligee gets paid first. And that was that case that involved, remember, I think it was Lambda took over 90% of the loan, and they didn't have a clear subrogation agreement going on. So the original bank got to take its 10% out first before Lambda got anything. Yes, sir. Okay, you want me to briefly explain subrogation again? Okay. Let me get my eraser. It's Mr. Burse, is that right? You weren't in that last class, day class, where I so nicely explained it on the board, or do I? Okay, but I'll do it again, because I'm sure that you're not the only one who could use another review of subrogation. Those of you who have your notes, if I forget something, maybe you can help me out. The ninth division didn't ask that question and didn't get the benefit. Where did I put? Please don't tell me I mixed my personal. Yeah, I did. It's writing of some kind. Aha, I hid it for myself. There we go. Subrogation. Somebody have the articles in front of themselves?
1825.
Okay, from 1825. I guess somebody really leaned on this at some point.
When a person is substituted for the right of the money.
The substitution of one person, I'm sure it could be more than one person, to the rights of another. In other words, substituting new obligee for old obligee. Okay? What does that mean for the old obligee? As for him, the obligation is extinguished. Okay? So now you owe the same, you as the obligor owe the same obligation, security, pledge, surety, whatever it was that was securing that obligation, you owe it to the new obligee. Okay? It can be either conventional or legal. That means automatic by operation of law. Conventional means by contract. Okay? Conventional means by contract. And you can effect a conventional subrogation either between obligee and new obligee, or by obligor and new obligee. Okay? There are two ways to do two kinds of contracts where you can do that. Now, there is one instance where the code says you need a particular kind of writing. If the obligor is borrowing money to pay obligee, so one, then the contract must say something about subrogation with obligee two. Okay? The obligor, if it's an agreement between the obligor and the obligee, the new obligee, okay? And the purpose of that is for the obligor to borrow money to pay off the old obligee. Then for the new obligee to become subrogated, there has to be some language to that effect. Okay? Do you remember the case where we had the guy that was interested in investing in some construction business, and he went to 4 obligees and had them sign subrogation agreements? Okay. That wasn't quite this instance, right? Because that was new obligee with old obligee. That was an example of this one. That was an example of this one. Okay? And it did say the subrogation, so it was nice and clear and it worked beautifully. Okay? But it could just have said something like, I hereby pay off the debt owed you by so-and-so, and you are now giving me all the rights and privileges you had. It could be that easy. But if it's here, let's change the facts a little bit. Let's say the guy is struggling, he's short of money, the debtor is struggling, he's trying to build this project, he's short of money, so he goes to, let's see, who does he go to? He goes to the guy that founded Keynes, okay? And he says, I'm really struggling to pay these subcontractors off. Could you loan me some money to cover me for a while? And the guy who owns Keynes says, yes, as long as you subrogate me to their rights over you. Okay? Because usually if you pay the debt of another, you just have the right to get the money back from them. You don't get their same rights and privileges. Okay? You just become another creditor. But to subrogate yourself, to step into the shoes of the other obligee, the obligor has to stipulate, I am borrowing this money specifically so that I can subrogate obligee number 2, the owner of Keynes, in place of that nasty bank I had originally borrowed the money from, or in place of these contractors. Okay? Otherwise, you wouldn't know. Paying the debt for another person, that other person owes you the money, but you don't get all the rights and privileges against them that the original obligees had unless you say something. Okay, legal subrogation takes place automatically. In which instances? One who pays another with a superior ranking. Okay, right, remember that? One who pays another with a superior ranking in favor of an obligee who pays another obligee whose right is preferred to his because of privilege. That was the, remember, several mortgages? One who uses purchase money to pay the seller's pre-existing secured creditors. And this is buyer of an immovable. Third was owes a debt with and for others. The fourth one was uses own money to pay succession debts. And the fifth was other. Okay. Now, let me see. Maybe I can, I don't know if anybody can see this. Yikes. I can't. Let me get my head out of the way. I'll have to recopy it. Somebody want to take a picture of it with their camera and email it to me? Cell phone? Email it to me. And then I can post it. Yes, ma'am.
What would be an example of that third type where it says owe the debt with and for others if it's not expressly put into the contract?
These are all legal. They're automatic by operation of the law.
Right.
Okay. So, we had some cases on that one. If you have, it gets a bit complicated, but let's take you have a solidary liability, solidary debt. If Mo pays off the debt that he and Curly and Larry owe to Shemp, pays all of it off, then he is subrogated to Shemp's rights over the other two, but only to what extent? To the extent of their virile portion. Okay? There's a limitation on that says when, let's see, 1830, when subrogation takes place by operation of the law, the new obligee may recover from the obligor only to the extent of the performance rendered to the original obligee, may not recover more by invoking conventional subrogation. So Mo couldn't go to Shemp and say, look, Shemp, if I pay off the whole thing, for you, can you agree to subrogate me to your rights? And then he goes to the other two and says, well, instead of your virile portions, guys, you have to hand me the whole thing. Okay. So that's what that article is saying. Other questions? You guys look exhausted or terrified. I want to assure you that this is probably the most straightforward, direct, and I wouldn't say easy test, but it's comprehensive. So to that extent, it's not easy, but it's not tricky. There's nothing on that test that we haven't discussed probably more than one time in class. Okay. It's not involving tricky questions. The only thing, as I said, that I thought that we should have covered more is the prescription on revocatory actions. Prescription on revocatory actions, but that's about a 2-minute learn, okay? And that's for the purposes of this test, and it won't go away. Okay? You'll have an understanding of that. It's a straightforward exam. It is somewhat long, but it's broken into manageable pieces. So, you know, don't feel threatened by it. Just get your rest. Make sure you have reviewed everything, and then come in fresh for your exam. And yes, ma'am.
The first 30 minutes is for outlining, kind of like we should do in contract.
I would not do that.
You don't do that.
No, I don't do that. The way you should approach hypothetical questions is not to give the first 30 minutes to outlining. It's to devote 1/3 of the time allocated to that question for outlining. Okay, so if you have a hypothetical worth 150 points, that's what, an hour and a half? So how much time should you spend outlining for that hypothetical? 30 minutes, okay? If you have a next hypothetical is worth 100 points, that's 1 hour. How much time should you spend outlining for that question? 20 minutes, right? 1/3 of an hour is 20 minutes, okay? The reason why I don't suggest you outline for the first 30 minutes is that you can't really comprehend or focus on every issue that's asked in the test at that point. You can focus more closely when you have to read the exam question, the hypothetical, that twice through, okay? It gives you a more focused way of outlining instead of a generic outlining for the whole thing, okay? So I don't think you should write out your course outline on the scratch paper. The point of the outline is to outline your answer, not your course outline, okay? Make sense?
Yeah, which is
Okay.
actually the same as the contract exam, where
The first
part of the exam was dedicated to, we had to read our hypos and write everything out. Because you graded on that also. Like the T-charts.
What I asked for was the T-charts, and I think you misunderstood. I wanted you to devote 1/3 of your time for each question, not 1/3 of your time at the beginning of the test to outline, okay? Okay? So to the extent I didn't make myself clear enough the last time through, I'm glad you're still here, and do it, try it this other way this time. I think you'll get a better result, okay? Yes, ma'am, there was a question in the back? No? Even Miss A2 has run out of questions? Okay.
Can you model a T-bar?
Can I demonstrate a T-bar? Okay.
For whatever question.
Let's say that you've identified, okay, subrogation. Okay, let's say it's conventional. Or EE or EE or. And then you would say, let's say it's this one and it's Max and Cheryl. Then if it's ob E, or, Then you would need writing and purpose or object is subrogation. And here you would say, perhaps it's ambiguous. And Max's argument, yes. And Cheryl's, no. Okay? And facts. Okay? So what I just did was a T-bar for what turns out to be an ambiguous question where it's not clear. Okay, so that then you know in your analysis you want to do both of them. It might be that when I wrote out this outline, I wasn't sure. I knew I had to have this, but I couldn't figure out the facts, so I just put a question mark. As I write out my rules, subrogation is the substitution of one person to the rights of another. It can be either conventional or illegal. If it's conventional, it can be between obligor and obligee or obligee and obligee. If it's obligor and obligee and the purpose is to borrow money to pay off the original obligee, there is no subrogation unless there's a writing saying that. Oh, okay, now I got it. Max's facts indicate, this is why it's ambiguous for his side, and this is, I may have to go back to my T-bar to add in stuff. Your brain will start working. It will, once you write out the rules, sometimes the analysis isn't that clear. You don't get those inferences until you've written out the rule. That's why I never want you to write CRAC. That's why I want you to write IRAC. State the issue is whether there is a conventional subrogation. Not the issue is there is a conventional subrogation and it's effective. That would be CRAC. Okay? But if you write the issue is whether, you're giving yourself time to rethink through the facts and do that. Okay? To come up with reasonable inferences from the facts. Okay? Usually the facts will be clear. It's harder for me to write ambiguous questions. I try to include at least one on a test. Okay? But it's harder for me to write. It's harder for any professor to write ambiguous questions. But you have to keep ambiguous fact patterns, in other words. It's harder to come up with fact patterns that are ambiguous. So usually there is one answer that's going to be more likely than another. But if it's ambiguous, you want to identify that it is and then argue both sides. Start with the one that you think is weaker and end with the one that you think is stronger and say that you think that stronger one will win. Other questions, problems, concerns? No? Pardon? Can we reschedule the exam? I don't set those times, and I've been informed by my superiors not to do that. Ms. Cruz, I have that information about that LLM program for you on faculty. So if you'll follow me to my office, I'll get it for you. Okay, 1 hour and 19 minutes and we are done. Hope you guys could hear me.